kick off. So hello and welcome to Law Week. My name's Dougherty and I'm a Senior Associate here at Nicholes Family Lawyers. Before we begin, I would like to acknowledge the Wurundjeri people who are the traditional custodians of this land, and I pay respects to the elders both past, present and emerging of the Kulin Nation and extend any respects to any Indigenous Australians that are present here with us today. I'd also like to note that this session is being recorded, and if you could please pop all questions into our chat function, we'll try and answer as many as we can at the end. So today I'll be moderating a panel discussion on the legal framework in Victoria that underpins assisted reproductive technology, the rights and responsibilities of parents and donors, consent, common misconceptions, and the legal status and regulation of donor arrangements and surrogacy. So to this end, I'm glad to be joined today by Dahl, a partner here at Nicholes Family Lawyers, and Dr. Sarah Nowoweiski, who is a doctor at the Newlife IVF. So does counselling, donor and genetics manager at that Newlife IVF. So thank you for everyone who's joined us today for this pertinent discussion. And I'll be moderating by posing some questions to our panellists. So welcome, Sarah and Beck.
Thank you.
Thanks, Eve.
Okay, so Sarah, could you please kick off our discussion by telling us what assisted reproductive technology is and how that process may look at Newlife IVF?
Sure. So assisted reproductive technology, or just commonly referred to as ART, broadly encompasses IVF procedures and artificial insemination procedures. So there are a range of fertility treatments that can assist couples. So if there is a couple that have been trying to conceive and experiencing difficulties, then there are a range of procedures and treatments available to try to help them achieve their pregnancy. And also for same-sex couples and single women, we have some donor programs to help families start to build their family. Yes, so at Newlife IVF, we're a purpose-built clinic at Box Hill. We have our purpose-built lab that has the state-of-the-art equipment and microscopes and technology available. We really focus on personalised care. So we know that all individuals and couples have very unique experiences of fertility and unique fertility challenges. So all of our treatment regimes, all of our treatment plans and all of our departments are designed to cater to the needs of each individual. So we really focus a lot on communication, and patients can expect a team approach when they come to Newlife. Yeah.
Oh, that sounds great. So where would we, if we were wanting to come to Newlife IVF, are we best to reach out by phone or email or on the website?
Absolutely. So we have Facebook and Instagram. Our social media has a lot of helpful information. Otherwise, our website would be really helpful if you just let us know. There's an application form on the website. If you'd like to put your details there, then one of our staff members can contact you and just talk to you about your options. Yeah.
Oh, fantastic. Okay, well, thanks, Sarah. And Beck, could you shed some light on the legal framework that underpins assisted reproductive technology?
Sure, just a little question there, Eve, to start off.
Sure.
But yeah, I'm going to start by outlining some of the history of ART law in Victoria. And much like Sarah, I'm going to use ART because otherwise I think we've been here all day saying assisted reproductive technology over and over again. But in Victoria, we have that treatment regulated by the Assisted Reproductive Treatment Act, which again, I'll call the ART Act for ease today. And interestingly, although not surprisingly, given how wonderful we are here, Victoria was one of the first jurisdictions in the world to legislate this kind of healthcare. And we've had a number of changes. I looked at some statistics, and in 2021, 4% of babies born in Australia were conceived by ART. So I'm not sure if I was surprised that was more or less, but that's the sort of numbers in the last couple of years. Some big changes we had in Victoria was in 2020, the government removed the requirement for criminal record checks and child protection order checks to be carried out before treatment procedures. And that was a really important move because what it did was removed some of those aspects of the law that were particularly impacting LGBTIQA plus people because of their reliance on ART, perhaps more than other parts of the community. And then we had some more changes in 2021 that the Victorian government really focused on making ART more accessible, equitable and affordable for Victorians, which is great. So Section 10 of the ART Act talks through the circumstances in which a person may undergo a treatment procedure. The person undergoing the procedure and their partner, if they have one, must have consented to the procedure. And in some cases, the patient review panel has to decide that there's no barrier to that treatment. For people who don't know, the patient review panel is a panel. It does what it says on the box, but its purpose is to determine applications by people who want to access ART where certain permission is required to do so. And those sorts of things are surrogacy arrangements where that surrogacy is going to occur in Victoria, the posthumous use of gametes and embryos, when they might believe that a child who'll be born might be at risk of abuse or neglect, and the use of some genetic diagnostics for the purposes of sex selection. So they're the sorts of cases where the patient review panel needs to get involved. If those circumstances aren't in place, it's also looking at whether if the person wasn't to have ART, there would be a risk to them or the child in having that baby.
Okay. Well, that's great. Thank you. So, Sarah, what are the key rights and responsibilities for parents and donors?
Sure. So in donor arrangements, we have very clear conversations with donors and recipients. I'll start from the donor's perspective. So donors sign consent forms to give away their legal rights and responsibilities. So they're very clear if they donate. So with egg, sperm or embryo donors, for example, if a child is born as a result of their donation, then the recipients or the parents are the legal guardians of any child that's born, and they are on the birth certificate and the donor is not on the birth certificate, which really suits all parties because donors are generally trying to be altruistic and generally trying to help some other people have a family, and are not looking to be parents themselves of this particular child. Also in Victoria, there's very clear legislation that donors can't be paid for their donation. So we're allowed to reimburse them. When we have a sperm donor, for example, who comes to the clinic, we can reimburse him for his parking when he comes to the clinic and any specific time that he's had off work that hasn't been compensated by his work. But we're just not allowed to financially reward donors in Victoria. So ultimately, the model in Victoria is altruistic. Thirdly, once a child turns 18, so if there's any child born as a result of a donation, once they turn 18, they are allowed to find out the identity of the donor, just for social and emotional reasons. So still the donor is not legally responsible for a child, but research shows that a lot of donor conceived offspring are curious about where they came from and have the ability to have access to the donor if they wish to down the track. So donors are aware of this when they consent to treatment, and also in Victoria, donors aren't able to direct their donations. So if they would like to be clinic donors, so for example, if a man would like to be a sperm donor to Newlife, we talked to him at the start about he can't have a particular say on the types of recipients that he donates to. So he's made well aware that any type of recipient, so whether they're heterosexual, same-sex, single woman, all types of backgrounds in terms of access to his donor sperm. Also in Victoria, a donor can consent to up to 10 women to have a baby with his donor sperm. We're talking about sperm donors. So there's a 10-woman limit in Victoria, so that there's not hundreds of children born from one donation. In regards to recipients, we also have very clear consent forms about the rights and responsibilities that recipients are accepting when they undergo treatment. If a recipient person or couple achieves a pregnancy, then it's very clear that they are on the birth certificate and they're the legal guardian of a child. If a recipient uses an identity release donor, for example, an egg donor or a sperm donor or an embryo donor that they don't know themselves, but they've recruited through the clinic, then down the track, they can also make an application to find out the donor's identity, and they can support their child if they wanted to make an application about the donor's identity in the future.
Okay. Do donors, are they notified if there is a child born of their donation?
We ask them what their preferences are. So a lot of our donors, talking about sperm donors, for example, they're very curious about whether a child is born. So they're allowed to find out what we call a family audit. So they can find out if a baby has been born, gender at birth, and the month and year of birth. So our donors are often incredibly proud and really excited to hear that a baby's been born. So sometimes we get to know, we develop quite a relationship with our donors and we get to know what they would like. A lot of the donors like to be called, and I think it's one of the best phone calls that we get to make to our donors, is to let them know a little girl is born or a little boy is born, and they're often very excited to hear that. So yes, they can.
Oh, that's lovely. That's great to know.
Yes.
So thank you. Over to you, Beck. What does the law say about the legal status and the regulation of donor agreements and arrangements and surrogacy?
Yeah, look, it's a great question. And I guess what I would preface it with, Eve, is saying that dealing with law and legislation and regulation can be really difficult, I think, for intended parents who just want to have children, and suddenly there's this barrage of legal hurdles facing them, and you know, trying to navigate the law while you're dealing with the emotions. So for us as family lawyers, I think it's really important to try and make that information as accessible as possible, just to really help people on their journey. So I guess picking up from some of the things Sarah said, so the ART Act has a number of sections that relate to donor arrangements and surrogacy in the regulation. So section 5C of that Act talks about what Sarah was just discussing, where children who are born of using donated gametes, so eggs or sperm, have a right to access the information about their genetic parents. Sections 58 and 59 of the Act outline the disclosure of certain information to people born from those treatments. There's a lot in the Act about surrogacy. Again, going back to the requirement for the patient review panel, and the requirements of the clinics to have that information from the patient review panel. Section 40 of the Act lists some of the things that are considered by the patient review panel when they're determining surrogacy agreements, and some of them are really, you know, interesting, or I guess important to know, and these are very specific to Victoria. So if a woman is going to be a surrogate in Victoria, she has to be over the age of 25. In Victoria, she has to have had a child before. That's not the same in every state, but in Victoria, that's the case. And there has to, both parties have to have had counselling on a number of important issues, and one of them is for the intended parents, if perhaps the surrogate, you know, doesn't want to give them the child, and vice versa for the surrogate if the intended parent. So they're really specific things in that section of the Act that people have to have counselling about. And again, as Sarah said, also in the legislation covering off the fact that a surrogate can't have any material benefit from the surrogacy arrangement. So yes, you can reimburse the reasonable costs. And it's also interesting to note that any surrogacy agreement that people enter into, which does have a level of reimbursement, is actually void as an agreement.
So with the material benefit back, that doesn't just mean a cash payment either, does it? That includes gifts that bestow any kind of benefit on that person.
That's right. It really, the legislation uses the phrase material benefit or advantage. And look, there's a lot of talk in Australia about our current regime and the law governing it. Obviously, we have the altruistic regime. There's countries like America who have a very commercial regime where women can get paid. And then there's countries like, say, Canada that have a bit of an in-between. They have a compensated model. So it's really interesting to kind of, understand how different countries, I guess, manage it, but very, very much in Victoria and Australia more generally, it is that altruistic model.
Yeah. So moving on then from the altruistic side of things to consent. Consent is a key part of the legal framework. So can you elaborate on the specific consent requirements as they relate to parents, donors and surrogates, Beck?
Yeah, so look, there's been a lot of changes in the law recently around consent. for example, Section 11 of the ART Act talks about the consent requirement. So that's where we go to find that information. And look, consent is the person undergoing the treatment and their partner, if they have one, consenting to the procedure, the specified procedure. And that consent can't have been withdrawn or lapsed before the treatment takes place. And the person giving the consent has to give that consent to an ART provider like Newlife or Sarah is to carry out the procedure, or the doctor in charge of the woman's treatment. So the other important issue around the consent is something we've mentioned a couple of times now, but Section 13 of the ART Act says that before a person consents to undergoing a treatment procedure, they and their partner, if they have one, have to have had counselling from a counsellor who provides services for an ART provider. And the other important thing to keep in mind is consent for the donor. Their gametes, so their sperm or eggs, can only be used if they've consented to the treatment of that kind. And with embryos, it has to be both people, so the sperm and the egg donor of the gamete have to have consented to that embryo being used. And then there are sections of the Act which talks about withdrawal of consent and what that looks like, because obviously that does happen and can happen, that people withdraw their consent. And under the Act, a donor's consent lapses 10 years after it's been given, or if the donors consented to a lesser period.
So thanks for that, Beck. Sarah, could you tell us a bit about the process for donors and recipients at Newlife IVF? What does it look like at your clinic?
Yeah, absolutely. And just to follow up on some of Beck's comments, the counsellors, the counselling process is really embedded into all treatment and procedures, and we spend a lot of time. So I know there's a lot of consent that's required for donors and recipients, and we spend quite a lot of time with all parties to make sure they really feel informed and have that chance to ask lots and lots of questions about their consent before they go through treatment. It is quite a specific consent form that we have in Victoria, so we just make sure everyone has a lot of time and capacity to be able to reflect and ask a lot of questions about their consent. But yes, just to give you a bit of an overview, so the processes, of course, differ if you're being a known donor versus a clinic donor. So generally speaking, though, if a donor would like to donate, then we have a donor team that first of all does an intake phone call with our donors to tell them a bit about eligibility, make sure that they're able to be donors, just go through some of the main points of the legislation and just talk to them a bit about the time commitment that's involved in being a donor. Then one of the next stages is to talk about the medical screening. So before anyone becomes a donor, they need to have some fertility tests themselves. So an egg donor would need to have some ultrasound, or a sperm donor would have a semen analysis. We do some thorough screening blood tests and also a reproductive carrier screening. So we can test for a lot of common chromosomal abnormalities these days as well, and a lot of carrier status for all of our donors. The donors would see a doctor and do like a medical and genetic health history as well. So overall, our donors just need to be in good health. If they have a partner, their partner also needs to be informed and participate in the process as well. And then there's a lot of counselling that begins. So in Victoria, donors and recipients legally must have at least 2 counselling sessions, and sometimes they're group sessions, but also we can have some more sessions to make sure everyone's as informed as they possibly can be. And so for counselling, so for example, for a donor, then some of the things that we talk about, all the implications of donating. So how they might feel if a child is born, the implications for them, if they've got support systems, have they told their families and friends, and making sure they're aware of all the legislation. So it can take an hour or 2, and that's why it does take a couple of counselling sessions to make sure everyone's really informed. It's really important that donors in particular, it's a very kind, generous offer to help someone have a family. It's really important that they've thought through their decision, they're aware of the future implications for them. So 10 years, 20 years, 30 years down the track, that they're aware that offspring could make contact with them and potential implications for their life. And I suppose just level of insight for them and maturity, just making sure they really understand the impact for them and their families if they have one for their decision. So, and then for recipients, they undergo some really similar processes. So recipients also would see a fertility specialist and check their fertility status, and that would help us decide what kind of treatment they might require, whether IVF or artificial insemination. They see a nurse once a treatment plan has been prepared, and the nurse would help them go through and prepare for the exact treatment cycle they would go through. And recipients also have several counselling sessions with our team of counsellors, and also undergo some screening tests, so reproductive carrier screening. So we need to make sure both reproductive partners, so the egg and sperm provider, are not carriers for the same condition. But yes, all the counselling would go through their consent process. Undergoing fertility is such a unique experience when you go through fertility treatment, and sometimes there's a lot of grief and loss. There's a lot of pain associated with some difficult decisions that you make when you're going through fertility treatment. Other times there is some excitement and some joy about the chance of having a family. So we really tailor all the counselling to each particular patient and their partner. Yes, that's sort of an overview, I suppose. And then we sort of orient them to the clinic and make sure they're aware of the team of people around them, and just give recipients a really good understanding of what to expect from Newlife. So they have their team of counsellors available, they have their nursing team, finance will help talk them through Medicare rebates and such. And the laboratory, we talk to them about the entering the lab, and the embryologist when they give them updates on embryos and their treatment as they go through.
Wow, it sounds like a really comprehensive service that you're offering there.
Yeah,
that's fantastic. It's great to hear. Well, thank you for that, Sarah.
Right.
Beck, could you please talk us through the process for donors and recipients from the legal standpoint?
Yeah, so look, the ART Act, again, it's an act that covers a lot of things, as I'm sure people are starting to realise, but it does talk about the issues we've talked about around consent, importantly, counselling and not being able to receive that financial benefit. And it's about a lot of the consent and legal issues under the Act really talk about the specific kinds of treatment that people are having and the real specific needs for consent, and also looking at, how and why it is that this person needs ART, and that they're not able to have a child any other way, or if they are, that there's risk to them or the child if they don't go through that process.
Yeah, okay. So, Sarah, what we've been going through is a lot of the legal side of things and the factual side of things, but as we know, there's many common misconceptions about surrogacy and donor arrangements. Are you able to shed some light on some that you come across?
Yeah, absolutely. I think the main ones that come to mind, there's a misconception that gay men can't be sperm donors. So they certainly can. So I know Victoria has different rules about whether gay men can be blood donors, but definitely gay men can be sperm donors. We also have any type of person can be a sperm donor. So we have transgender sperm donors as well. So we just have, there's just a few misconceptions about eligibility for being sperm donors.
Yeah.
I think one of the other misconceptions is that for sperm donors, again, there's concern that there will be hundreds of children born from their donation, or there's a sense of lack of control about what happens to their sperm. So all donors, including sperm donors, have very specific rights in terms of how many women use their sperm. So a sperm donor can just consent to 1 or 2 women using their sperm, or 5 or 6, or the most at the moment is 9 women using their sperm. So they do have a significant element of control about who is able to use their sperm. I think one of the final misconceptions perhaps is about the future and the concern, if you're a donor, that there will be lots and lots of offspring showing up on the doorstep in a few years' time. And I don't think movies help in this regard, sometimes perpetuating this misconception. But it's just not like that. So we have, in Victoria, there's a Victorian body called VARTA, which is the mouthful. It's Victorian Assisted Reproductive Treatment Authority. They manage what's called the Central Register, and there's some excellent processes that we have now. So if an offspring or parents of an offspring would like to make an application about information about their donor, there's a lot of really clear processes in place. And it's done in a very structured way. So sperm donors are given some choice in terms of and information. So they're communicated with in terms of when information is being released, how it's going to be released. Donors do get quite a bit of information with that family audit. They obviously can know how many children are born and how old they are, so they can have a little bit of an idea in their mind about when offspring might be making contact in the future. And there's also, again, a lot of counselling that's involved just to help prepare all parties if a meeting is going to be taking place or if identifying information is shared. There's a lot of discussion and just talking about expectations of all parties and making sure people are as informed as possible.
Okay.
So those are the main ones I can think of.
Yeah, that's fantastic. And I'm aware that on your website, so that's www.newlifeivf.com.au, you've got a section there that is sperm donation separating fact from fiction. So that's a good place for other people to have a look as well.
Absolutely.
So adding to Sarah's response, Beck, are there any common legal misconceptions that you might be able to clarify for us?
Yeah, look, there's a lot. And it's, I think it's an important part of our job is helping people unpack those misconceptions because as Sarah said, I think sometimes movies and those sorts of things do us a little bit of a disservice. But one I wanted to pick up on, which is not common, but has been in the news in the last couple of years is around the posthumous use of gametes. So when a person's deceased, and you might have seen in the media Chumpy Pullen, who was a Winter Olympian, died, and his partner was able to access his sperm after he died and had a child. And so it is something that people think about. But again, these are very state-based sort of legislations. And in Victoria, courts do allow gamete retrieval from a deceased person up to 48 hours post-death. However, the recommended period for retrieval is 24 to 36 hours after death. So it's a real timely sort of issue. However, if a court does allow for that retrieval, it actually doesn't automatically allow the surviving spouse to use the eggs or sperm for an IVF procedure. And in Victoria, there's really strict regulations. So the treatment has to be carried out on the deceased person's partner. The deceased person, importantly in Victoria, has to provide written consent for their gametes to be used in this specific procedure. So for this specific purpose that the person wants to use it for. The patient review panel has to have approved it, and the person has to undergo counselling, which, as we've learnt today, is a really important part of any of these procedures. But what's really relevant in Victoria is that the legal system here really strictly enforces the requirement for written consent, and the written consent has to specify the circumstances. So what I mean by that is, say, for example, a deceased person had provided written consent, say in their will, for the use of embryos formed by their sperm or eggs, but not the sperm or eggs themselves, then that's not considered consent if they'd only provided it for the embryo. And it's really strictly applied in Victoria. In other states in Australia, the consent doesn't have to be written, but in Victoria, it's really important. So it is something for people to think about and get legal advice if that's something that is important to them and they might want to have in their will. The other, I guess, legal misconception or legal concern that people have is about who is the parent of a child that's born through ART, because obviously, we have the genetics and then we have the people that care for the child, and there can be some confusion there. So effectively, being a parent gives you the authority and responsibility to make decisions for your child. So long-term decisions around things like medical, education, passports, all those sorts of things. And generally, that responsibility falls to the person who's the parents of the child. But obviously, in some ART procedures, that's not always clear. So in taking the example of surrogacy, when a child's born as a result of surrogacy, at the time of the child's birth, the surrogate is listed on the birth certificate as that child's parent. And if the surrogate has a partner, that person is listed as the other parent, and the intended parents, as we call them, so the parents who are going to raise the children effectively, don't have that legal parental responsibility at the time of birth. Now, we do have a process in Victoria that allows for a transfer of that responsibility to the intended parents, and that's a process through the County Court of Victoria, and you can then get a new birth certificate issued. But it is important to understand and know that that's only for altruistic surrogacy arrangements that have taken place here. We haven't touched on international surrogacy today, but that's a different issue. So I think that's a misconception too, that people are not always sure, you know, who is the parent, and sometimes we do need to have these legal mechanisms because the law as it stands very much directs that, I guess, initial parenting responsibility to the person who's given birth to the child and their partner if they have one.
Great. Well, thanks, Beck, and thank you, Beck and Sarah, both for your insight. I'm going to hand over to the audience to ask any questions. They can go into the chat function, or if you would like to ask them, you can do so as well by unmuting yourself.
We did have a question even in the chat box saying, can my ex-partner give consent to use his sperm as a donor? I'm not sure if that's donation to yourself or someone else, but he's able to give consent in the same way that Sarah and I discussed to donate his sperm to yourself, even if you're his ex-partner or someone else. Is there, Sarah, anything you wanted to add on that?
That's correct. So that happens sometimes. So if a couple, for example, are going through fertility treatment together and then they decide to separate, but they may still have embryos in storage, one person can become a donor for the other person. So they can, they decide that they don't, the person who is not having treatment will not be a parent, but can give consent for their either embryo or gametes to be used by the other partner. So relationships are hard, life is hard and complicated sometimes. So lots of things happen all the time. So we just have some really good discussions, make sure everyone's clear and informed, and just obviously talk about all the emotional issues involved. But that's right, obviously you can, an ex-partner can become a donor.
Sarah, can I ask you a question?
Yeah, of course.
Off script. When we were talking about the misconceptions, I know that you sort of hear, oh, there's no sperm available for women, or sometimes you hear there's lots of sperm available. What is the reality in terms of if people are wanting to use an anonymous sperm donor and recruit through a clinic, the availability of that?
Yeah, absolutely. It's always has been a little bit hard. So there has been a well-documented sperm shortage in Victoria across all states of Australia, really. And so recruiting sperm donors or trying to have enough sperm donors available for recipients has always been a challenge for all clinics in Victoria. The reality is, so at the moment, I guess I can speak for Newlife IVF, we've benefited from some amazing sperm donors. So our donor program has been open for about 3 years or so, and we currently have about 16 donors available at the moment. So we feel as though we have a really robust, healthy donor program, and just completely indebted to the amazing people that have decided to become sperm donors through our clinic. So we've been able to help lots and lots of women have babies so far, but it is always hard. So being a sperm donor, for example, does require a lot of time commitment. So there's a lot of time off sometimes. You need to come have some counselling sessions, you need to come into the clinic to provide sperm. So I think for a lot of men, the desire to help people is there, but then sometimes it's a little bit hard to make time to come in. So I just think I've been doing this for about 20 years, but every day I'm still delightfully surprised by the generosity of people in the world that want to help others have a family. So yeah, in terms of speaking for our clinic, I suppose anywhere between sort of 10 to 20 donors are available at any given time, and they're from a range of backgrounds and personalities and hobbies and interests and just different types of people. But it is hard. It's sometimes, obviously, if you're a recipient in choosing a sperm donor, it's really important to find the right donor for you. So if you have some particular ideas in your mind about the type of sperm donor that you're looking for, sometimes there's a little bit of wait until you find a donor that's right for you. Yeah.
Yeah. Yeah, great.
Yeah. And are you able
fabulous.
to Is there an ability to utilise overseas clinics to, I guess, import sperm?
Yeah, so in Victoria, we do have to get approval from VARTA, that company I was talking about earlier, to import donor sperm from overseas. Newlife has a relationship with the European Sperm Bank, so we have approval from VARTA to import certain donors from the European Sperm Bank to make available for our recipients. But yeah, so people, we can have very specific discussions with any person who's looking at international programs. The main thing is making sure, obviously, the main thing is in Victoria, the Victorian rules still apply. So if you import a donor from overseas, they need to have not been paid and need to be open identity sperm donors, and some of the main factors that VARTA would consider. Yeah.
Okay.
Happy to
that's excellent.
anyone if they had any specific questions about that.
Yeah, perfect.
Yeah.
Well, I think that is the main questions answered. So thank you all for joining us to discuss the assisted reproductive technology and the legal framework that underpins it. It's an evolving area of law, so it's really important that everyone remains at the forefront of the recent changes in the legal landscape. At Nicholes Family Lawyers, we provide sensitive and tailored advice to couples who are seeking to undergo assisted reproductive treatment to conceive a child. And to find out more about your legal standing and options to help you to assist starting a family, please give us a call and we'll be more than happy to assist. And for those looking to start their IVF journey, please reach out to Dr. Sarah at Newlife IVF. There's 3 fertility clinics across Melbourne offering an outstanding fertility treatment personalised to your needs. So thank you once again to Beck and to Dr. Sarah for joining me today and what's been an insightful panel. And that concludes our seminar today.
Thanks, Eve.
Thank you.
Thanks, everyone.